Welcome to this presentation in which we're going to cover the beginnings of Module 3, which is primarily about Title VII. Title VII is by far the most important statute that we're going to be talking about in this course, and we'll be spending several lectures on it. This lecture is an overview of it, and then in subsequent lectures we'll do a deeper dive. So let's begin. We're going to first of all talk a little bit about the history of employment discrimination law in the United States. We're going to do an overview of Title VII, and then we're going to talk about a few, not just a few, but the several laws that follow Title VII, although we're not going to talk about them in great detail because, again, those will be covered in separate sessions. And then not in this lecture, but in future lectures, we'll talk about some of the theories of employment discrimination. You'll see that we'll be revisiting some ideas that we talked about in Module 2. And finally, we'll talk about the EOC charge process, again, a topic that we touched on in Module 2. So let's begin. So I think it's helpful when we talk about Title VII to go back in time a little bit to see kind of what was going on at the times where these laws were developed. Now let's go back a really long time into the 1860s, right after the Civil War. And as I'm sure you know, there were 3 important amendments to the Constitution at that time. And many times those are called Reconstruction amendments. During the time after the Civil War, we call that period historically, obviously, the Reconstruction. We were reconstructing the United States into one nation. And much of that work had to do with addressing concerns that African Americans had about safety, about being citizens, about being eligible to vote, about participating in the economic life of the community. Obviously, the solutions that were developed in the 1860s were woefully inadequate, but there were efforts in that direction, we'll say. So the first one is the 13th Amendment, which abolished slavery. You don't need to know about it for this course. The second one is the 14th Amendment, and we do talk about this one from time to time in the course, although it's certainly not a major emphasis. This has to do with the rights of individuals to receive equal protection under the law. And it also created limitations on things that states could do with respect to citizens. It used to be until the 14th Amendment that the Constitution was simply about what the federal government could or could not do to an individual. It didn't have really any discussion about what state governments could or could not do to an individual. To find out those protections, you needed to look at the state constitution. But that changed to some degree with the 14th Amendment. And so many of the protections, though not all, but many of the protections that we find in the first 10 amendments to the Constitution, which we call the Bill of Rights, now started applying, at least partially, to state action. And when I say state action, I mean the action of state governments. So this has some relevance to us in this particular course, but not a tremendous amount. Another big thing that the 14th Amendment did, which isn't directly relevant to this course, but still really important, is how it established on a constitutional basis the fact that somebody who is born on U.S. territory is a U.S. citizen automatically, even if his or her parents were not U.S. citizens and or were here without the appropriate documentation, so to speak. And so this has a little bit of relevance to our course, but for the most part, the 13th and 14th Amendment is not a major theme we have. The 15th Amendment, of course, is another important amendment. It has to do with voting rights, really important subject, but beyond the scope of this particular class. Okay, so we have 3, this slide has 2 of them, but we have 3 statutes that we're going to talk about briefly. The first is Section 1981, and that's really what it's called here. So when I refer to it and when you talk about it in your practice, this is what it's called. This little sign here, which looks like an S stacked on top of another S, is what we call a section symbol. So it's like this, S, and then another S, like that. Anyway, so Section 1981 is an important statute that does have real implications in employment law. Now, it is a Reconstruction era statute, so we're thinking back to, again, I think 1866, but it's really more recent updates to the statute that makes it particularly relevant for us. So what does it do? It prohibits racial and national origin discrimination in contracts, including employment contracts. And so you can see this sounds very much like what we've talked about with Title VII. So you may say, why do we need Section 1981 if we have Title VII? Well, the reason we need it, or at least plaintiffs want it, is this magic little word right here. There are uncapped or unlimited damages that the plaintiff can be awarded if, of course, he or she is successful in a 1981 claim. There are significant caps and limitations under Title VII. So if you happen to work on the plaintiff's side of the bar and your client has a race or national origin claim, you want to certainly advance a Title VII claim, but if you can, you also want to advance a Section 1981 claim, because that creates a larger amount of money that your client can potentially win. And that's important for a couple of reasons. Number one, you may end up going to trial and the jury may award you a very big verdict. That's awesome and wonderful. And of course, if the jury awards you a big verdict and you have a Section 1981 claim, it means you and your client get to keep that money, right? So that's a successful outcome for sure. There's another advantage to Section 19, well, actually there's several advantages to Section 1981, but with respect to the unlimited damages aspect, and this is probably the more important aspect, is that the vast majority of cases, including employment law cases, settle before trial. And so this gives the plaintiff a stronger argument for higher damages. And so therefore it means it's very likely that the plaintiff will be able to negotiate a higher settlement amount if he or she is also asserting a 1981 claim. Now, in order to advance this, you have to have a race claim and or a national origin claim. So a gender claim, a religion claim, an age claim, a disability claim isn't going to work under Section 1981. Then we have Section 1985, which most of y'all, if y'all are historians or political science folks, probably know it as the Ku Klux Klan Act. Of course, Ku Klux Klan is an abbreviation for the KKK, a racist organization that was involved in a lot of violence and lynching and other activities, primarily against African Americans and in some cases against Jewish and Hispanic individuals. Anyway, this law was to undermine the ability of the Ku Klux Klan to operate. So it wasn't a pro-Ku Klux Klan law. It prohibits concerted activity, the type of activity that the Ku Klux Klan was engaging in the Reconstruction era, to deny someone his or her rights based upon his or her race. So again, this was designed to protect African Americans. It obviously didn't in all cases work by any means, but at least the concept was positive. And now we have our third Reconstruction era Civil Rights Act, and this is Section 1983. This is also an important law. Nowadays, this is probably, it isn't as important as 1981, but for our purposes is the second most important. And this prohibits state action, and by that we mean government action, not just action by a state government, but also action by the federal government and by local government. It prohibits that action, a particular action, when it deprives civil rights. And we call this concept under color of state law. So let's look at what this term means. This is our first vocabulary term in this module. And this is an important term, not just in this course, but you'll see it in many other courses. And it's a fairly common expression that legal professionals use. So saying that somebody's acting under color of law, first of all, has nothing to do with literally color, brown, blue, green, purple. And it has nothing to do with race issues, although I guess in our context, it indirectly has to do with race issues. But the word color in this context is not referring to skin color. It's referring to the authority of the law. So operating under color of law means that the action is being done under the appearance of legal authorization, even though really it isn't legally authorized. So if I'm a government official and I say, oh, my interpretation of this law is that you have to pass this literacy test before you can be eligible to vote. Well, but that's not what the law says. Well, my interpretation of the law is that you need to. So therefore, I'm claiming to act under the authority of the law, even though, in fact, I don't have that authority. So here's another example. A government official illegally discriminates against another government official during the performance of the first government official's official duties. So if I work for the government, let's say I'm a clerk of the DMV, and my supervisor discriminates against me because of my race or my religion or whatever, and that's an unlawful action on the part of that individual, then there is a Section 1983 claim that I can advance. Now, this can't be used by private employers because, of course, a private employer never operates under color of law. He doesn't or she doesn't have any authority under law. So because we focus on private employment in this case, I'm probably not going to talk about Section 1983. I mean, it'll probably come up again, but it won't come up commonly. The statute that is by far the most important of these three for our purposes is Section 1981. I know I don't have it in red, but I encourage you to add it, at least this one. Don't worry about the other two, but add this to your Quizlet so you'll have this. And of course, this is a pretty effective definition for that statute. Well, let's consider the scenario. Mary is a U.S. citizen who is ethnically Asian. She works for a state government. She's denied a promotion. She feels it's because of her ethnicity or her race, because a white worker who scored lower on the test was promoted in her stead. So under those circumstances, she can bring a claim under the 1983 because it appears that somebody in her state government organization deprived her of her civil rights through state action as they claim to operate under the color of law, even though they were violating the law by doing so. Now, if we were to change the scenario and make this a private company, then we would change the statute to 1981. And obviously, as you probably can tell, these aren't years. These are, there's a list of sections to this particular statute. So we are on the 1981st section, and then this one right here that I just crossed out is the 1983rd section. Okay, so we're going to go back to that Civil Rights Act of 1964, which Title VII is but one part of. You can probably hear in the name that there were other parts, right? At least 6 more, right? So the part we focus on is Title VII, but it's by no means the only focus of the statute, or some would even argue not the most important part of the law. As you may recall, or if you were alive then, but if you weren't, and I wasn't, so there you have it. I'm not claiming to be alive at this time. The country was experiencing a significant amount of civil rights advocacy, and the civil rights movement was robust and getting more robust. In 1963, in November, President Kennedy was assassinated, but he had already put into motion efforts to pass a civil rights law. And once President Johnson became president, he continued that initiative. And one of the challenges with the Civil Rights Act of 1964 wasn't just getting it by Congress, but it was also getting it by the U.S. Supreme Court, because the U.S. Supreme Court's position had been that these laws were unconstitutional because they violated the 10th Amendment. The 10th Amendment to our Constitution is one of the 10 Bill of Rights that we have kind of at the beginning of our amendments that are designed to extend to us certain rights. Well, one of those rights has to do with the rights of states to not be subject to federal interference in the sphere of affairs that is the responsibility of states. And so the U.S. Supreme Court said, Congress doesn't have an enumerated power. Remember, we talked about this in an earlier lecture. Congress doesn't have an enumerated power to get involved in civil rights issues. There's nothing in the Constitution that gives Congress that authority, and Congress can only pass laws based upon areas in which they have the enumerated right. And so therefore the 10th Amendment would say, and does say in the opinion of the U.S. Supreme Court before 1964, well, under those circumstances, states can pass civil rights laws if they want to. They don't have to. It's their choice, and they can put whatever provisions in those laws that they want to. But that's not the responsibility or even the appropriate area for the federal government. So when the people were drafting, when the Congress and the President working together were drafting the Civil Rights Act of 1964, they knew that they had to figure out a way around this problem of the 10th Amendment. And so what they did is they said, well, what about interstate commerce? I mean, the federal government does have an enumerated power here, and certainly when you have racism, that affects employment, and that employment affects interstate commerce. Also, other titles of the title of the Civil Rights Act of 1964 had to do with economic issues other than employment. And so the idea is those are affected, interstate commerce is affected when racism is permitted to flourish. In addition, we have the 14th Amendment as also being another path, which we just finished talking about. Let me flip over, just remind you which one the 14th Amendment is. It says all citizens were granted equal rights under the law. And so obviously individuals who were being denied their civil rights, potentially that could be a violation of the 14th Amendment. So here is literally the language from the Interstate Commerce Clause, which is part of the original U.S. Constitution. Now, this, when you hear, I love this section of the Constitution because it sounds so out of date and somewhat out of touch. It just reminds us that the world that our founding fathers were in is so very different than our own. So this is how it's literally written in the Constitution. Congress is allowed to regulate commerce with foreign nations and among the several states and with the Indian tribes. And you can see kind of random words like commerce are capitalized. This first part probably makes sense with foreign nations, but among the several states, that's a funny expression. And with the Indian tribes, again, a focus that we typically don't have, and yet a large part of the country was organized or would be organized by a separate Indian or Native American nation. So what these words mean was a matter of a lot of debate. If we were to look before the Great Depression, this clause of the Constitution had a very limited meaning. People really thought this was not very important or glamorous or a clause that gave the Congress much authority at all. During the Great Depression, we talked about this earlier, Roosevelt really wanted to expand this meaning so that he had more ability to roll out a variety of economic policies, because he hoped that by stimulating the economy or giving additional protections to workers, that would be able to get us out of the Great Depression in some kind of organized effort, as opposed to each one of the 50 states kind of doing its own thing. And so He was somewhat successful, initially not successful at all, but he was eventually able to persuade the U.S. Supreme Court that federal laws relating to union organizing were constitutional under the Commerce Clause. So now we're fast forwarding about 30 more years. And so this is another opportunity that Congress is going to have to perhaps extend people's understanding of the Commerce Clause even further. And I'm not going to give away the whole story at this point, but a preview is that we still have this law today. So guess what? It must have been upheld as constitutional. So this very unglamorous Commerce Clause went from being, kind of a trivial part of the Constitution to being probably the prime source of federal regulatory power today. When the federal government regulates our economy or does environmental regulation or most types of regulation, its enumerated power that it relies upon, that the Congress relies upon, is the Commerce Clause in the majority of the times. Now, it also has a taxing authority that's found in the Constitution, so it's not always the Commerce Clause, but the Commerce Clause is probably the source, well, it is clearly the source many, many, many times in this area. So here is the important case. I did not post this on Canvas. Certainly you can find it on your own. This is the case that held that Title VII, as well as the rest of the Civil Rights Act, was constitutional. This is hugely important because if the U.S. Supreme Court had gone the other way and found that it wasn't constitutional, I think that we would all be living in a very different country and certainly in a very different state. And so this was a very, very significant moment in our history. So did Congress exceed its powers under the Commerce Clause by enacting the Civil Rights Act of 1964? And the U.S. Supreme Court said no. Now this case actually does not relate to employment, so it did not directly address Title VII. There was a hotel, or I guess motel, in Atlanta that excluded African Americans as guests. This was, unfortunately, during this time period, very common for many hotels to do so. And this hotel was one that advertised prominently. People would be traveling, and again, it's before the internet, and so people, and somewhat before many of the hotel chains that we currently think of. So one way that a hotel, especially one that wasn't part of a chain, might be able to persuade people to stop at their place would be through advertising. And certainly this hotel had a national advertising campaign. It used billboards and other ways of communication. And so the U.S. Supreme Court said it is engaging in interstate commerce because many of its guests are from other states. It is advertising in media that is interstate, meaning it's communicating to lots of different people in other parts of the country. And so therefore the motel was subject to the reach of the Civil Rights Act. And under those circumstances, it would have to comply, meaning that it would now have to accept as guests African Americans. And of course, the logic of this opinion then, of course, applied to Title VII. Okay, so that's a little bit of history. You do need to know the name of this case. You don't have to know the facts, but you do need to know it's the one that held the Title VII to be constitutional. And you ought to know that it was through the Commerce Clause. I think I had some of my slides out of order. When I went through this particular lecture, I caught a few typos, and I also saw that at least one slide was out of order. So as we're going through this, you may see a few points where you may want to change, cross out, or add words from the words that are visible in your version, because I have not gone back and changed the PowerPoint that's posted or the study guides. Okay, so the Civil Rights Act was all about race. We've talked about the other categories like sex and religion and national origin, but for sure the guiding force, the motivation behind the law was racial discrimination. And again, if we go back and look at the history of this issue, it's easy to see why this was the force that was most important. And I have a few points here to share. Certainly, Brown v. Board of Education is not a employment case, but it's an indication of that continuing effort to extend the same rights that white people were enjoying to African Americans as well, and to remove the burdens of Jim Crow. Obviously, other groups were also at times experienced some level of oppression. Certainly, there's been sexism, there's been colorism, there's certainly been discrimination based upon religion, but certainly those perhaps are less, in many cases, less severe problems than what African Americans were experiencing in the 50s and 60s. So the Civil Rights Act, again, wasn't just about employment. It was about education, public accommodations. This would be things like airplanes and buses and trains, and the receipt of federal funds. And again, the bases were race, color, and we'll talk later about the differences and similarities between race and color. They're related terms, but they do have some differences. I have the term gender here, but some people use the term sex. They both have relevance. National origin, again, we'll talk more about what that means in a later lecture, and religion. It was actually JFK who insisted that employment was included. He was obviously passed away at the time that the law actually became the law, but he certainly was actively involved in negotiating it and contributed significantly to its passage. So again, Title VII is the employment law section. After Title VII was passed, many other states passed similar laws, and Texas is one of those states. Our equivalent law is very, very similar. In places, it's identical to Title VII. So there's a lot of similarities there, a lot of commonalities between that. In fact, nowadays, the vast majority of states have a law similar to Title VII. There are a handful of states that don't. I know in the past, Alabama did not. That may or may not have changed. And I think Georgia may not have. And there may well be other states as well. In some sense, it's not necessary that a state have a similar law because Title VII applies in all 50 states. And so it doesn't really mean that people in Alabama are somehow going to be less protected from employment discrimination than somebody in Texas or a state that already has this type of law. Obviously, there have been EEOC regulations. The Equal Employment Opportunity Commission was created by Title VII. Every government agency needs an enabling statute that creates it and that gives it the authority that it has. And so the Title VII Civil Rights Act created the Equal Employment Opportunity Commission, which is commonly called the EEOC, and gave it the authority that it does have. And obviously it's issued many regulations since then, many of which we will talk about as the course progresses. So here is a definition of employment discrimination. A limitation or denial of an employment opportunity based upon a class characteristic of a person. Now you can see this is more limited. You know, we talked before about how discrimination can mean when you're just you are just separating people, and sometimes the separations make sense. For example, whenever I interview, say, 3 candidates and I hire one of those candidates, I've discriminated because I'm saying I prefer Bob over Larry and over Susan. It doesn't mean that I've engaged in this type of discrimination, It may be that Bob is more qualified, and if Susan or Larry were to review the resumes, they might well agree, yeah, I'd hire Bob if I were you. It may not be at all a controversial decision. But we're not using discrimination in that sense here. We're using it as in the sense that a person is being subject to adverse action of some type in the employment context because of protected characteristics such as race or religion or national origin or age or sex, etc., etc. The most common term for this is adverse employment action. And sometimes an adverse employment action can be inaction. For example, if I'm not hired, we consider that an action. Or if I'm not promoted, we consider that an action. So it's not always an action so much as an inaction. Sometimes people think, well, my boss is a bigot, so therefore I've got a claim under the employment discrimination. You may well have a claim, but bigotry in and of itself isn't the basis for a claim. It's very good evidence, but you have to point to a particular decision that was affected by the bias. And so if you can't point to that decision, then you haven't yet been subjected to the bias. Now, obviously, somebody who is sharing bigoted views is probably engaging in employment harassment. And so that, of course, would be a protected category, too. We'll talk about harassment both in the context of racial harassment as well as sex harassment in later modules. All workers, all employees have this protection. You may recall in our first module, we spent a lot of time defining what an employee is. And we saw in some statutes, especially the National Labor Relations Act, that supervisors and managers were excluded from coverage. Title VII doesn't exclude any worker, any supervisor, or any manager from protection. So anyone who isn't an owner of the business, and actually in some cases even owners of the business, partners, can be protected under Title VII. But anyone who's drawing a paycheck is going to be covered if, again, they're not an independent contractor and their particular employer employs enough people in its workforce. So we're going to end this lecture at this time. When we return to our next lecture, we'll be covering an overview of Title VII. Thank you for your attention, and I hope you have a wonderful day.